All right, welcome. The Berkeley Law Advocacy Competitions Program and the Board of Advocates is pleased to introduce the Bales Trial Competition Final Round. We've started out with 20 teams of 2 each and their witnesses, and we are down to the final 2 teams, the final 4 competitors. The students went through 3 trials already to narrow down this field. They're all 1Ls, getting for most of them, their first taste of trial work to see if this is something that they would like to pursue. We welcome everybody who's viewing tonight. We have some previous round competitors, maybe some previous round judges, and friends and family of the participants. So welcome, and I'm going to introduce a few of the folks you will see tonight. We have Judge Sandra Bean of the Alameda County Superior Court, who will be presiding. And our jurors are Jonathan Laba of the Contra Costa Public Defender's Office and Spencer Pahlke, who is a partner at Walkup Melodia, Kelly and Schoenberger and runs the trial team program here at Berkeley and is a wonderful alum. So we just thank all of you for being here. I want to give a special thanks to Ashley Adesoy and Blake Dancer, our student directors who have organized the competition and done everything from selecting the problem to setting up scrimmages for teams and registering students and answering student questions, running student training. So everybody give a quiet shout out to Ashley and Blake.
A motive, a plan, an email. Members of the jury, I am here with you today to illustrate how these 3 elements show that Jordan Belfort is liable for the charge against him. We are here today because Mr. Belfort has been charged with insider trading. Although this case has many details, these 3 elements make Mr. Belfort's liability abundantly clear. The fact that he had a motive, that he constructed a plan, and that he sent an email to D. Azoff acknowledging his motive and plan. I owe you one, and you know I'm about to make it up in a big way. This is how Mr. Belfort signed off on an email to D. Azoff on December 14th, 2019, the same day that Elon Musketeer had contacted Mr. Belfort to make an investment offer in his company, the same company that D. Azoff was also a shareholder of. Mr. Belfort's motive was his indebtedness. We all have at least one person in our lives who has supported us either financially or personally, and whose support we feel compelled to reciprocate, sometimes out of gratitude, but sometimes out of obligation. We are here today because of Mr. Belfort and Mr. Azoff's relationship, a relationship that was beginning to appear one-sided. Mr. Azoff had invested in a number of Mr. Belfort's startups, and he had lost a significant amount of money, particularly in one. But Mr. Azoff nevertheless continued to support Mr. Belfort in his autonomous vehicle company, Lakma No Hands. But in 2019, Mr. Azoff realized he wasn't getting much in return for his investments, and he began to sell some of his LMNH shares. Mr. Belfort sensed Mr. Azoff's waning support, and he knew he had to financially make it up to Mr. Azoff, or he would lose the support of his most loyal and primary investor. But that's not all Mr. Azoff was to Belfort, a loyal and primary investor. Mr. Azoff was also a close friend. The two were so close that they spent winter and summer holidays with each other and each other's families at their respective vacation homes. But Mr. Azoff always paid for the transportation, and Mr. Azoff also paid for more of the dinners, more of the tickets, more of the travel expenses. Essentially, Mr. Belfort was indebted to Mr. Azoff on two fronts, in his business life and in his personal life. This brings us back to Mr. Belfort's motive. Mr. Belfort knew he had to prevent Mr. Azoff from losing any more money because he had already owed him so much and he had begun to rely on him. So Mr. Belfort and Mr. Azoff constructed a plan to get Mr. Azoff his money as to compensate him for his loyal support throughout the years, and a plan to maintain Mr. Belfort and Mr. Azoff's lifestyles of vacationing and traveling together. This is why Mr. Belfort wrote to Mr. Azoff on December 14th, 2019, saying, "I owe you one, and you know I'm about to make it up in a big way." The email. Members of the jury, our burden today is to prove to you Mr. Belfort's guilt beyond a reasonable doubt. Beyond a reasonable doubt is the highest possible burden of proof, but 3 elements demonstrate that this burden has been met. First, that Mr. Belfort had a motive. Second, that Mr. Belfort constructed a plan. And third, that Mr. Belfort sent an email to D. Azoff acknowledging his motive and plan. Today, you will hear that Mr. Belfort learned Elon Musketeer was interested in investing in LMNH on December 3rd, 2019. The two agreed to meet in Las Vegas the very next day. But on that day, on December 3rd, 2019, Mr. Belfort called Mr. Azoff to tell him of this news. And he also asked Mr. Azoff to borrow his jet for the Las Vegas meeting. And on that day, December 3rd, 2019, Mr. Azoff purchased 1,750 shares of LMNH. According to Mr. Belfort himself, Mr. Belfort kept Mr. Azoff updated on the status of the negotiations with Mr. Musketeer throughout December. And the record supplements this claim, as Mr. Azoff made significant purchases of LMNH on days corresponding to updates in the negotiation status. From December 3rd, when Mr. Azoff first learned from Mr. Belfort that Musketeer was interested in investing, to December 31st, when Mr. Musketeer's investment in LMNH became public, Mr. Azoff had purchased a total of 12,750 shares of LMNH and a net of 176 in options. At the end of this trial, my co-counsel, Dan Mateer, will come before you and hold Mr. Belfort criminally liable for insider trading. Hold him liable because 3 elements demonstrate Mr. Belfort's guilt. That he was motivated by his debt to Mr. Azoff. That he constructed a plan, one that may have existed as early as November 2019. And that Mr. Belfort sent an email to D. Azoff acknowledging his motive and his plan. Members of the jury, I ask that you keep these 3 elements in mind throughout this trial. And I ask that you hold Mr. Belfort liable for the charge against him today. Thank you.
Good evening, Ms. Gorman for the defense. Could you please introduce yourself to the jury?
Yeah, hello. My name is Jordan Belfort.
Where are you from, Mr. Belfort?
I'm from right here in Lone Star. I was born and raised here.
What do you do for a living?
I start businesses here in Lone Star. I've founded several successful startups, but for the past 14 years, I've been working on Look Ma No Hands. I was the chairman and CEO.
What is Look Ma No Hands?
LMNH, as I call it, is a self-driving car company. I concentrated specifically on developing the technology that lets a car drive itself and see its surroundings. Our ultrasonic sensors let us detect objects at twice the distance of any other system.
Is Look Ma No Hands a public company?
Yes, I took the company public in 2013.
How has LMNH been doing since then?
It's had its ups and downs. The development of the technology was more difficult than I could have imagined. Financially, things were always tight, but by January 2019, I knew that the technology would work. And in December 2019, we finally got the money we needed to keep going.
Now, Mr. Belfort, I'd like to talk through what happened in December 2019. You mentioned LMNH got money it needed to keep going in December 2019. Where did that money come from?
Throughout December, I was trying to negotiate a big investment in LMNH by Elon Musketeer. The investment eventually came through and put the company in a much better place financially.
Could you walk me through the process of negotiating Elon Musketeer's investment?
Sure. I first heard that he was interested in the company on December 3rd. A friend of mine had met with Musketeer that day, and she had mentioned our technology to him. He asked to meet with me in Las Vegas the next day.
At this point, did you tell anyone you had a meeting scheduled with Mr. Musketeer?
Yes, I asked the company lawyer to go to the meeting with me, and I told my best friend, D. Azoff.
Why did you tell Mr. Azoff?
I was so excited about the meeting. I needed to confide in someone. I needed to borrow his jet to fly the meeting on such short notice.
Now, we'll talk more about Mr. Azoff in a moment, but what happened in your first meeting with Mr. Musketeer?
I presented the technology to Musketeer, his CEO, and two of Musketeer's engineers. Musketeer asked if $1 billion investment would be enough to give him exclusive rights to our technology. I said yes, but Musketeer just said he would think about it on that first meeting.
At this point, how did you feel about the likelihood that a deal would be made with Musketeer?
Not great after the first meeting. It was clear to me that Musketeer was only mildly interested at the time. I was disappointed. I didn't think that Musketeer would actually come through with an offer.
Did you hear from him after that meeting?
Yes, I did.
When did you hear from him?
He finally called me on December 14th to say that an offer would be coming in the next few days.
Did you get an offer in the next few days?
Yes, but not a good one. On December 19th, Musketeer offered to buy 1/3 of LMNH for $17 a share, not even close to $1 billion investment.
Did you accept this offer?
No, I was pretty sure it wasn't going to happen immediately. I was pretty disappointed with the initial offer. I discussed it with the board of directors, of course, and together we decided to reject it.
What happened after you rejected that offer?
On December 22nd, Musketeer called again and increased the offer to $19 a share for 35% of the company. It still wasn't $1 billion, but it's certainly closer. I think the total value was about $684 million.
Did you accept that offer?
Yes, we accepted the offer that day.
Was news of Musketeer's investment ever made public?
Yes,
When was it made public?
we issued a press release on December 31st.
Okay. Now I'd like to talk a little bit more about D. Azoff. Prior to December 2019, what was your relationship with D. Azoff like?
D was my best friend for 10 years. We'd both been divorced around the same time, so we helped each other through that. That was hard. We both have 3 daughters. They're all best friends. They became really close. And we shared a love of skiing. I would often host him and his family at the Yellowstone Club, and Dee would host me and my family at his house in Deer Valley.
Did one of you host the other more often?
Oh, I didn't keep track. We were just friends, but we would usually alternate. I think, like most people, we tried to split expenses pretty evenly.
Did you often confide in Azoff?
Of course. Like I said, he was my best friend. After my wife and I separated, he was really my only confidant. I didn't have anyone else left after the divorce. I trusted Dee with everything.
Prior to December 2019, did Azoff ever betray your trust?
No. Before December, Dee was my most trusted friend, and for good reason. I knew him for a decade, and he had never once betrayed anything I shared with him.
Had you talked to Azoff about your businesses before?
Yeah, of course.
Do you know if Azoff had invested in your businesses before?
Yes, he did.
Had Azoff ever lost money in your businesses before?
Yes, once one of them didn't do as well as the others.
In your opinion, did he hold this against you?
No, he was an experienced investor and he invested because he saw the opportunity there. He knew it could go either way, so he didn't blame me.
Did you feel that you owed him anything because of that loss?
No, definitely not.
Did he continue to invest in your startup?
Yeah, he invested in Element H at the beginning.
Did you feel you owed Azov anything because of this initial investment?
No, the early investment is really a privilege. The investors saw a lot of opportunity to invest early on and make money. And they also know that they bear the risks as early investors.
Did you ever discuss stock trades in Look Ma No Hands with the Azov?
No, we never discussed trading in Element H. I'm not a particularly active trader in my own company stock.
Did you ever discuss stock trades in any other companies?
No, we never discussed his trades or my trades in any company.
Now, I'd like to talk more about what Azov knew about the potential Musketeer investment. Did you tell Azov about Musketeer's investment offers?
Yeah, unfortunately I did.
Why?
To be honest, at the time, I didn't think much of it. I told him as my best friend. He was really the one person I could really trust to keep the information private. We had a long history together. He was a vault to me.
To your knowledge, did the Azov trade Look Ma No Hand stock in December 2019?
Yes, I found out in early 2020 that D had traded Element H stock during that time and was being investigated for insider trading.
But back in December 2019, did you know that Azov was trading Element H stock?
No, at the time I had absolutely no idea. If I had known, I would have been furious.
When you told Azov about your negotiations with Musketeer, did you ever explicitly tell him not to trade based on that information?
No, I didn't think it was necessary.
Why didn't you think it was necessary?
I trusted him. He had always protected my private information in the past. And besides being my best friend, D was also a sophisticated investor. I assumed that he knew to keep the information confidential and not trade on it. He knew the law. I fully expected him to keep it confidential.
Now, Mr. Belfort, do you own stock in Look Ma No Hand?
Yes, I own about 20% of the company.
And did you trade in Element H stock at all in December 2019?
No, I didn't. I've never been an active trader in my company's stock. I just kind of see it through. But I also thought that doing so then might be illegal.
Have you talked to Azov since finding out that they traded Element H stock in December 2019?
No, I have been so upset with him. It's been hard losing that. I haven't talked to him since I found out.
Did you benefit from sharing information about Musketeer's investment with Azov in any way?
No, not at all. The only thing I got out of it was losing my best friend. I haven't talked to him since. It's actually been pretty hard for me and the girls. They haven't seen Dee's daughters as much. We all feel pretty betrayed.
Now, you were here when Agent Pat Denham brought up Exhibit 12, an email from you to the Azov on December 14th. I'd like to talk with you about this email. What was the status of your negotiations with Mr. Musketeer when you sent this email?
Let's see, this was on the 14th. I know that was the day that Musketeer called and said he would have an offer for me. I was skeptical that day that the investment would actually happen.
Could you explain why in this email you thanked Azov for his trust?
Yeah, sure. On these trips, it's usually D and I staying together so we can go skiing together. But on this trip, it was just my family. I wanted to thank him for leaving the place to us.
What did you mean by I owe you one?
I mean, it's just an expression. It was part of my saying thank you for using the cabin.
Finally, what did you mean by, I'm about to make it up in a big way?
Oh, I didn't mean much by it. I was thanking him for letting me use the cabin. And really, we were always taking trips together. And since this trip was so fun, I thought we could plan something extra special at one of my properties, maybe at the Yellowstone Club.
Were you implying that Azov should purchase shares in LMNH?
No, definitely not.
Thank you, Mr. Belfort. No further questions.
Cross-examination?
Counsel Mateer for the prosecution.
All right, go ahead, Counsel Mateer.
I just want to start off, Mr. Belfort, by talking about your personal relationship with Mr. Azov, if that's okay. So in December, you would have called Azov your best friend, right?
Yeah, he was.
And you've at points in the past called Azov your best friend for life, right?
Yes, I have.
And at points in the past, Azov has paid for your dinner, right?
Yeah, he's certainly treated me before.
And he's let you use his private jet for free.
Yes, he was very generous with his jet.
And he's let you stay at his vacations house for free too.
Yeah, he did. We would always take trips back and forth.
And in addition to these, personal costs, Azov also invested in your prior startups, right?
Yeah, he did. He saw opportunity in those.
And on one of those particular startups, Azov lost a significant amount of money, right?
Yes, I believe he lost some.
And despite losing this significant amount of money, Azov still invested in Lukmano Hands, right?
Yeah, it was a new opportunity and he saw a chance to make more money.
So I'd be correct in saying that Azov has spent money on your personal life and Azov has spent money on your professional life.
Spending is a little different than investing, but I guess I see what you're getting at.
You do not think that investing in a company involves spending money?
It certainly does, but with the expectation of return. That's why we all invest.
So just to be clear, I would be correct in saying that Azov has spent money on your personal life and spent money on your professional life.
Sure.
And on December 14th, you sent Azov an email that includes the quote, "I owe you one," correct?
Yeah, I just talked about that.
Sweet. So let's move on to talking about your communications with Azov throughout the month of December. So let's start with, on December 3rd, you have your first contact with Elon Musketeer, right?
Yes.
And right after that call, you call Azov, right?
Yeah, I did.
And on that call, you tell Azov about the Musketeer information.
Sorry, could you repeat the question one more time?
And on that call with Azov, you tell Azov about the Musketeer information.
Yes, unfortunately I did.
And you'd say that you did that because Azov is your best friend, right?
Yeah.
And as the Musketeer negotiations continued, as things progressed, you kept Azov in the loop. You kept him up to date, right?
Yeah, he was the one that I could confide in.
And in all of these calls that you're having with Azov, you're aware, of course, that to trade based on non-public material information would be a criminal offense, right?
Yeah, certainly.
And of course, you're also aware that the Musketeer information is non-public material information, right?
Yes.
So you know that when you're telling Azov about the Musketeer information, you're telling Azov non-public material information, right?
Yes, but specifically trusting him to keep that private.
So yes, you are aware at the time that you're telling Azov about the Musketeer information, that information is non-public material information.
Yes.
So then you would also have been aware at the time that if Azov was to go and trade based on that Musketeer information that you told him, that he could be held criminally liable, right?
Yes, certainly, but
And Azof's
trusted
your
him
best
not
friend.
to. Yes.
And as your best friend, you know Azof's tendencies, his personality, right?
Yeah, I would say so.
And despite knowing Azof's personality and his tendencies, you never explicitly told him not to trade based on the Musketeer information, even though you knew he could be committing a criminal offense?
No, because more than anything, I trusted Azoff to keep this information private. I never could have thought that he would trade on
It never occurred to you that he would trade on that information?
it. No, it would be illegal.
So just to be clear, you never explicitly told him not to trade based on the Musketeer information and during any of your phone calls.
No,
And you also never explicitly told Azoff not to tell anyone else during all of your phone calls.
no, but that was certainly implied. He knew that I was trusting him on this.
So you told Azoff about the Musketeer information and included no warnings about don't tell anyone, don't trade on this information, even though you knew that Azoff couldn't keep a secret, right?
Objection, Your Honor. Lack of personal knowledge.
Overruled. You can answer, Mr. Belford.
Yes, thank you. No, Azoff D had always kept my secrets in the past. I totally trusted him.
So I just want to be super clear for the jury. It is your sworn testimony today that you were under the impression that D. Azoff was very good at keeping secrets.
I had certainly trusted him with my own secrets. Absolutely. He was my closest friend.
So I want to be clear about your answer to the question. Is your testimony that you are under the impression in December that Azoff was going to keep your secret, that he was good at keeping secrets?
It was, well, I was most certainly under the impression that in December he would keep my information private and that he would keep these secrets. Yes, I fully trusted him in that.
Let's move on to talking about your relationship with Shannon White. So you know Shannon White, right?
Yeah, she had dated D.
And you would describe your relationship with Shannon White as a casual acquaintance, right?
Yeah.
And you maintain in your past testimony today that you told Azoff about the Musketeer information only because he was your best friend, right?
Yes.
And yet, didn't you also tell Shannon White, a casual acquaintance, about the Musketeer information?
I really don't think I did. I don't recall a specific instance of doing so.
So again, let's just be clear so the jury has all the facts on the table. It is your sworn testimony today that you did not tell Shannon White about the Musketeer information.
Yes. There were a number of instances that we saw each other. I suppose it's possible, but it would have been inadvertent. I don't recall a specific instance.
But you knew this information was non-public material information.
Yes, I did.
So your testimony is that even though you knew it was non-public material information, that you might have just let it slip once at a social gathering?
I suppose it's possible once it would have been inadvertent. I don't think I would have gone into the details.
So your testimony is that you definitely remember you didn't go into the details, but you're not sure if you told her at all, right?
I'm sorry, I'm not sure if it's possible that I might have inadvertently let something slip. I would think that I would have kept it general.
But you don't have your testimony is you don't have a specific memory to this?
Correct.
Let's move on to talking about something that you mentioned in direct. I believe that you said in your direct examination that on December 14th, the day that Musketeer first gives you a firm offer? I mean, let's just confirm that. December 14th, that's the first day that Musketeer indicates a firm offer is coming, right?
Yes, he called and told me that an offer would be coming in the next few days.
And on direct, I'm correct in having your testimony in that you were skeptical that the investment would actually happen, right?
Yes.
And on December 3rd, when you first learned about the Musketeer information, you were really excited, right?
Yeah, I was.
Did Musketeer tell you a firm offer was coming on December 3rd?
No, we had talked about potential numbers, but it seemed like it was in the realm of speculation.
So I've got your testimony right that on December 3rd, you don't know a firm offer is coming and you are really excited. And then December 14th, you learn that a firm offer is coming. You don't have any of the details about that offer and you are skeptical that it will happen. Do I have that right?
I certainly had my doubts about what was going to happen after the 14th. So, sure.
So just to clarify, you had no doubts when you don't know about a firm offer coming, and you're very excited, but you do have doubts and you're not excited when the firm offer is indicated that it will come on December 14th.
Yeah, I think on the 3rd, there was a lot of initial excitement that I was getting to talk to Elon Musketeer. By the time the 14th rolled around and it had been a while, it started to become a little more real to me. So I was unsure that we would get a realistic offer that we would actually accept.
But you had no concrete information between December 3rd and December 14th to damper the prospects of that firm offer, right?
No, just time and thought.
Just time and thought. So December 3rd, you learn about the possibilities of Musketeer information, and you're so excited that the first thing you do is tell Azov about the Musketeer information. But December 14th, firm offer is coming. It's concrete. And that email that you sent to Azov after, definitely nothing to do with the Musketeer information. I have that all correct?
Yes.
Let's move on to talking about your knowledge of Azov's trading activity in December. So as we've already covered, on December 3rd, you first talk to Musketeer about the possibility of an investment. You tell Azov, and then after that, he goes and buys a lot of shares of your stock, right?
I think I saw that in the table earlier.
And at the time that Azov is buying all these shares of your company, the public does not know about the possibility of a Musketeer investment, right?
No.
But Azov knows about the possibility, right?
Yes.
And Azov knows about that possibility because you told him, right?
Yes, unfortunately I did.
But when the public does find out, when the Musketeer announcement comes out, the stock price of your company, it goes way up, right?
Yes, it did increase after the investment.
And when the stock price goes way up after the announcement, Azov makes a good chunk of money based on those shares he bought in early December, right?
Yes, I'm not sure exactly how much he made, but he would have made money.
And the only reason that Azov was able to make this money was because he knew about the possibility of a Musketeer investment before everyone else, right?
Yeah, he really took advantage of that.
The only reason he knew about the Musketeer information before everyone else was because he learned it from you, right?
Yes.
So by telling Azov about the Musketeer information early, you helped Azov make money on your stock, right?
Inadvertently, but yes, I suppose so.
So that would be a yes. It was a help to Azov to learn about the Musketeer information early.
Yes.
And on December 14th, you sent Azov an email that says, I owe you one, and you know I'm about to make it up in a big way, right?
Yeah, we were hoping to take that trip together.
So that's a yes. The email, I owe you one, and you know I'm about to make it up in a big way, was sent from you to Azov, correct?
Yeah, I think you got to see it too.
So the last thing I want to talk about is your own stock holdings. So you own 20% of Lukmano Hands, correct?
Yeah, that's correct.
And shortly after Azoff learns of the Musketeer information from you, he goes out, buys a lot of shares, right?
Yeah.
And after he buys a bunch of shares of Lookman O'Hands, the share price of Lookman O'Hands goes up, right?
It increased in that time frame, but I believe from our third quarter results announcement.
So maybe I should be a little more specific. From December 3rd, when you first told Azoff, and then he bought a bunch of shares of Lookman O'Hands, the stock price increased on December 10th, correct? Over that 7-day frame.
Yes, the stock price did increase. I think we had just released our announcement.
You released your third quarter announcement, your November third quarter announcement between December 3rd and December 10th? That's your testimony?
No, I'm sorry. You're right. I had the dates mixed up. No.
So let's just reset and be clear. After Azoff buys shares of your company, your stock price goes up within 1 week.
Yes.
And when the share price of your company goes up, the monetary value of that 20% that you own, that also increased, right?
Yes.
And when the monetary value of the stocks that you own increased, that's a benefit to you, correct?
Yes. If you're implying that D's investments increase the value of my stock, that is highly unlikely.
When your testimony is that when the price of the stock that you own 20% of went up, you did not benefit from that increase.
Oh, no, I'm sorry. That's not what I'm saying. Yeah, certainly the value of my stock is tied to its price. But it seems that you're implying that that was correlated with D's purchase, which is highly unlikely.
Just asking a simple question. You benefited from the value of your stock price going up, right?
Sure.
No further questions, Your Honor.
Go ahead.
Your Honor, counsel, members of the jury, you just had a big day at work. Maybe it was a big promotion. Maybe you found out that your company is restructuring and you might be laid off. The big news hasn't been publicly announced yet, but you come home and you tell one person. You tell the one person who you trust more than anyone else in the world. That is what Jordan Belfort did. In December 2019, Mr. Belfort got exciting news at work. It wasn't definitively good news, but in the end, it wasn't bad news either. And when Mr. Belfort got that exciting news, he told the one person who he trusted more than anyone else in the world. He told his best friend, D. Azoff. Now, as you heard today, Mr. Belfort soon learned that that trust had been misplaced. His trust, which Mr. Azoff had never broken before, had been betrayed. Mr. Azoff took Mr. Belfort's exciting news and used that news to engage in insider trading. But today's trial isn't about Mr. Azoff. It's about Mr. Belfort. And as to Mr. Belfort, there was no motive. There was no plan. Mr. Belfort, ladies and gentlemen, never saw it coming. See, just telling someone your exciting news isn't a crime. As the prosecution got up here and told you, they bear the burden of proving that Jordan Belfort is guilty of each and every element of the charge of securities fraud. And they have to prove each and every element of the charge beyond a reasonable doubt. That is the highest burden of proof in our criminal justice system. And it means that you must be so certain that you wouldn't hesitate to rely on that level of certainty when making a big decision in your own life. And it's a burden that the prosecution simply cannot meet. You also must base your decision today on the evidence that you heard from witnesses here at trial. That means that when Mr. Meter tells you about things in his closing argument, for example, about a Barron's article that no witness testified to, you must listen to the evidence itself, not to the prosecution's closing argument. Just because the prosecution tells you that Azoff didn't do this alone doesn't make it true. That is for you, members of the jury, to decide. Now, let's take a look at just how the prosecution failed to meet their burden by comparing the story that you heard at trial today with each of the elements of the charge. Let's start with the third element, the easiest one. Because Mr. Azoff made his illegal trades on the Lone Star Stock Exchange, even though Mr. Belfort had no knowledge of these trades at the time, we admit the third element. But the prosecution has to prove all of the elements of the charge, not just the one. And to satisfy the first element, the prosecution had to prove to you that Mr. Belfort engaged in an insider trading scheme, that he provided D. Azoff with material non-public information in anticipation of receiving some benefit in return, and with the expectation that D. Azoff would trade on that information. Let's take this element piece by piece. Mr. Belfort admits that he told Mr. Azoff about the ups and the downs of his negotiations with Mr. Musketeer. Mr. Belfort told Azoff that he was excited about the possible investment, but that he was skeptical that a deal would actually go through. Remember that Mr. Belfort himself didn't know until December 22nd that Musketeer would make an acceptable offer. But even if you buy that the information that Mr. Belfort provided to Mr. Azoff was in fact material non-public information, that's not enough to satisfy this element. Because the prosecution also had to prove to you that Mr. Belfort expected Mr. Azoff to trade on that information. And none of the witnesses that you heard from today, not even the prosecution's star witness, Agent Denham, could tell you that Mr. Belfort expected Mr. Azoff to trade his company's stocks. Now, it was clear today that Agent Denham had his mind made up from the beginning. He believed Jordan Belfort was guilty from the beginning, and he tried to make the facts fit that narrative. But ladies and gentlemen, it is your job today to look at the facts. And as for the facts, Agent Denham himself told you that he couldn't find any evidence that Mr. Belfort told Mr. Azoff to trade his company's stock. Agent Denham tried to tell you that Mr. Belfort had a plan and that this plan was captured in an email. But when pressed, Agent Denham admitted that he never spoke to Mr. Azoff or Mr. Belfort in the course of his investigation. He never got to ask Mr. Belfort what his December 14th email was really about. But you got to hear what the December 14th email was really about. And the only thing that Mr. Belfort owed Mr. Azoff was a stay at his vacation home. Remember that by 2019, Mr. Belfort's company had the best technology around. He didn't need anything from Mr. Azoff, and he didn't owe him anything in relation to his company. And remember that in the end, Agent Denham told you that he just couldn't say for sure whether Mr. Belfort expected Mr. Azoff to trade. Now, because the prosecution has to prove each element affirmatively, that lack of evidence alone means that the prosecution has failed to meet its burden. But you also heard evidence today to the contrary. You heard Mr. Belfort testify that he never expected that Mr. Azoff would trade based on the private information that he confided in him. And you don't even have to take Mr. Belfort's word for it, because Mr. Azoff himself told you through his statement that he knew that Mr. Belfort was expecting him not to trade based on the information. And he knew that Mr. Belfort would be very angry with him for doing so. Finally, for this element, the prosecution had to prove, beyond a reasonable doubt, that Mr. Belfort anticipated receiving some benefit in return for telling Azoff about the possible investment. The record shows no evidence to support this claim. The two former friends split their expenses evenly. Now, the prosecution tried to tell you that Mr. Belfort benefited from Mr. Azoff's stock purchases in November and December because those purchases increased the value of LMNH stock, which Mr. Belfort owned some of. But they couldn't show you any evidence of how much Mr. Azoff's purchases would have increased the value of LMNH stock? Because that evidence simply doesn't exist. The reality is that Azov's purchase of less than $300,000 worth of stock simply would not have changed the share price of what Musketeer valued as a more than $1.4 billion company. And even if Azov's purchases had changed the LMNH stock price, Belfort couldn't have anticipated that benefit, because as both Mr. Belfort and Mr. Azov told you today, Mr. Belfort simply didn't know that the trades were happening. Instead of benefiting, Mr. Belfort lost his best friend when he found out that Mr. Azov had betrayed his trust and traded an LMNH stock without his knowledge. Now, let's talk about the second element that the prosecution has to prove. For this element, the prosecution had to prove that when sharing information with Mr. Azov, Mr. Belfort acted knowingly, willfully, and with the intent to defraud Lookma No Hands. Now, Mr. Belfort admits that he knowingly shared confidential information with his best friend. And if he shared that information with anyone else, it was inadvertent. But let's look at the terms willfully and with intent to defraud and see why they don't apply here. Willfully means deliberately and with a bad purpose. Mr. Belfort didn't act with a bad purpose. He was merely excited about the possibility of a major investment in his company, and he confided in his best friend. Now, intent to defraud is only satisfied if Mr. Belfort intended to deprive his company of the confidentiality of its information. He did not. As you heard from Mr. Belfort and Mr. Azov, Mr. Belfort expected Mr. Azov to keep the information confidential, to not share it with anybody else. Mr. Belfort certainly expected that Mr. Azov, a sophisticated investor who had never before betrayed his trust, would not trade on the information. Now, these are a lot of terms, but luckily the instructions that you will be provided with today give you a simple way of thinking about all these words. The instructions tell you clearly that the law is not violated if the defendant held an honest belief that his actions were proper and not in furtherance of any unlawful scheme. This guidance clearly applies here, where Mr. Belfort honestly believed that he was simply sharing exciting news with his very best friend. The instructions here also take us right back to where we started, to that burden of proof. They remind you that we, the defense, never had the burden of proving good faith. The prosecution had to prove it, and every element beyond a reasonable doubt. But today, you heard reasonable doubts. Mr. Azov and Mr. Belfort split their shared expenses evenly. That's reasonable doubt as to whether Mr. Belfort received a benefit. Mr. Belfort was so upset when he found out that Mr. Azov had traded based on the confidential information that he hasn't spoken to his former best friend since. That's reasonable doubt as to whether Mr. Belfort anticipated the unlawful trades. Mr. Azov himself knew that Mr. Belfort expected him to keep the information private. That's reasonable doubt as to Mr. Belfort's intent to defraud. And finally, Mr. Belfort explained what he meant to you when he told Mr. Azov via email, "I owe you one and I'm going to make it up to you." That is reasonable doubt. In the end, the prosecution simply hasn't proven each of the elements beyond a reasonable doubt. For Mr. Belfort, there was no motive, there was no plan, and there was no incriminating email. Mr. Azov